Mr. Chandhiok noted in its order that there is nothing on the record to suggest that the individual property of the promoters that have proposed the settlement amount is subjected to restraint by the Enforcement Directorate. And they have also sort of clarified that the settlement amount can't come from proceeds of crime. Now, who will take the onus and the responsibility to determine that this is not proceeds of crime? Are the usual sort of vetting, processes by the banks will take care of the fact that this is not proceeds of crime?
No, obviously it will be the PMLA's authority which will have to take. ED will have to take that call. If ED is able to bring that evidence before NCLAT tomorrow to say, look, this money which is coming into this resolution plan is actually tainted money, obviously NCLAT will take a look at it. But it's the authority which must do it, which is the mechanism available with the bank to see, unless per se the documents itself speak about it, that these are proceeds of crime. If I have people coming from outside, they have their bank account, they have sufficient means to show that, then whether their money came into their account through some proceeds of crime will be a question of investigation by the authorities. How will the banks will be able to establish it? As long as you are able to show the credibility of that investor into the corporate data. So therefore PMLA, therefore the ED would probably make a representation before the court, before the NCLAT, and then show that this is the evidence available to me with me today to show that this money, even if brought into the country, would be a tainted money, and therefore this can't be allowed. Therefore, what are you actually saying? By allowing a 12A petition, you are actually violating another provisions of law which can't be the principle that Indian jurisprudence stands on. Consequently, you should not allow 12A to take place. That's a different context, that's what I'm saying. So you're actually creating an exception yourself, because you're violating another act to support another provision or a resolution in another act, which can't be done. It can't be that I steal money and then come forward and say, no, I'm making a resolution plan. It can't be done. I agree with that part. But the question would be, it will be that authority which must place before the court or before the adjudicating authority in the first instance, that this evidence is sufficient for you to come to a conclusion that the creditors have not taken an informed decision with respect to the 12A application. It is possible. I am not saying no, that it can't be a case where in no case will the NCLAT or adjudicating authority will have jurisdiction to say no. But having said that, you can't prima facie, just because some investigation is going on, that you say that this money becomes tainted. I don't think we have, in law, everybody is stated to be innocent till proved to the contrary. So therefore you must have some cogent evidence to satisfy the judicial conscience. That's all.
Sure. Yeah, Piyush, just I'll add to this one point with Mr. Chandhiok made, that this is very cute, right? Now, in addition to the ongoing criminal investigation that the Enforcement Directorate is carrying out against the company, every time now a payment happens under this OTS or one-time settlement to, let's say, the COC and the other creditors, the ED will then check that trail of money as well?
See, not in each case. This is
not each case. I'm just practically figuring out how will this work, given what Mr. Chandhiok has said, that it can't be up to the banks to figure out how that money has come to the promoter group. So now it becomes the ED's job to vet the settlement amount?
So in effect, ED is already seized of the matter.
Okay.
And wherever ED is already involved, they will obviously have to be referred the matter before a settlement is allowed with the promoter. So in all cases where ED is already investigating, so for example, let's say theoretically Gitanjali, let's say there was a settlement offer. Already ED is seized of the matter, and ED can say whether the money that has come in is okay or not. And that's, while we are yet to hear the last word on it, my sense is yes, that will be the correct view to take, because ultimately nobody else certifies what the proceeds of crime or not. So tomorrow, let's say a deal goes through which had proceeds of crime, commingled in it, which got discovered by ED later. ED comes and attaches the property.
Okay.
So I don't think that there is any issue on that. PMLA jurisdiction of ED stands irrespective.